We're online, right, Kelly? Okay. I'm just waiting for it to turn 8 o'clock. Let's call the meeting to order. The first bill for our consideration is House Bill 161 engrossed, loan disclosures for guarantors and co-signers. Representative Jennings, good to see you.
Thank you, Mr. Chairman. Committee? Go ahead.
Go right ahead.
Does clock start now? 3 minutes. So, Chairman and committee, this is about consumer protection. It's a constituent-driven bill, and it's not something that's necessarily always not being done incorrectly. Many loan institutions already do this. So I had a constituent that brought this to my attention. They'd go in and they would co-sign on a loan. And they had the thought that, you know, a house or a piece of equipment or a vehicle, that if they did not, if the person defaulted, that they would continue as the agreement for co-signer was, they'd continue paying, and then that object might be theirs, or that property, that real property. And so on a fourth, fifth, sixth time that they had done that, one of the loan officers says, you realize you don't get the property necessarily unless there's another contract. There's a contract between you and the person. And so they did not realize that. I had not thought about that. I mean, I think some people do, people that in a lot of the banking institutions, like I said, a lot of loan officers probably already do this. That's my understanding that they do. But in the cases where they don't, what we're asking for in the bill is very short, as you noticed, is that when they give you that book of things where you sign off, the disclosure would basically say you do not necessarily get, or you do not get rights to the personal property, even if you pay it off. It's the other person's, because they're the one we're in contract with, you know, in the bank. And so the amendment on the other side was to put it on the same stuff that they already have, the paperwork that they give. So we don't want to create a bunch of new paperwork. We don't want to create, it's just a consumer protection idea that says you may want to enter into a separate contract to determine who gets the real property if the original signer defaults. And Senator, that's basically the bill. It's just a very short consumer thing of disclosure from the loan institutions to say, you may want to think about a different contract if you have interest in procuring. If you're the one that ends up paying, if there's a default, you may want to enter into a contract elsewise.
Okay, questions for the representative? Any questions for the representative? Senator Barlow?
Thank you, Mr. Chairman. So my question is there a definition of co-signer in statute currently? Thank you, Mr. Chairman.
Representative Jennings?
I believe there is, Senator, but I do not have that in here.
We got some experts back behind you.
Yeah.
Anybody else? Senator Landon?
Thank you, Mr. Chairman. So the language says that the disclosure shall provide notice, the cosigner, that agreeing to be a guarantor on a loan does not by itself confer any right to said property. What exactly does that mean, Representative?
Representative Jennings?
That, Mr. Chairman and Senator Landon, is that the notice itself does not provide a right to that personal property. The notice is telling them that they may want to seek other legal remedy to create a contract or something. It's saying that notice in and of itself is not giving them a right, a personal property right.
Back to you.
So a quick follow-up. Thank you, Representative. So I assume that the lending institution can probably come up with a document that says if I end up paying this off, you know, for my relative here, I want assurances that that property will be conveyed to me. But you're saying that it just takes some kind of different documentation or some different kind of
Representative Jennings?
Mr. Chairman, Senator Landon, it's just saying that they may want to go put that in a separate contract, that it is not guaranteed to them by the notice.
Okay.
So Representative Landing, I think from the bank's point of view, they just look and the loan's been paid off. And it was, they have to follow the contract where it says when it's paid off, they convey the title to Joe Blow. And that's the unhappy father's no good kid, is the way that works out. Representative Jennings.
The other thing that I'd put to that is that really with the loan institutions, what this really is just a point of order. It's really just a point of information that says you may not get this property unless you have a separate contract.
And I think that separate contract would be between the cosigner and the main person taking out the loan, right?
Correct.
Okay.
Mr.
Doesn't really
Chairman.
have anything to do with the bank or?
No. Mr. Chairman, the bank is only a point of information.
Gotcha.
It seemed like it was the best place to insert an institutional information part that says, look, you don't necessarily get this property unless you take care of that.
Okay, anybody else? Thank you. We'll hear from the audience out here. Who would next? Would the banking commissioner like to address us? Welcome. How's it going? You spent a lot of time in here this year.
Good morning, Mr. Chairman. Jeremiah Bishop, State Banking Commissioner and head of the Division of Banking. I think this is the first time I've gone before this particular committee during this session anyways. So just a little bit of a background.
Must be our judiciary committee that you're working
I
hard
see
at.
that one quite a bit.
Yeah.
So,
We have kind of the same players in both in a way. There's a
Definitely.
couple of us. Back to you, sir.
Thank you, Mr. Chairman. So our office, we administer Title 13, and we are the bank regulators over state chartered financial institutions, which includes state chartered banks, and we enforce Title 13 on those banks when it applies. So this bill is pretty simple, I think, and I just want to go through a few things to clarify some points. A co-signer and co-borrower, they sign the same loan agreement as the borrower does. That's just the agreement to pay back the loan. It determines the payment, terms of the loan, payments, due dates, things like that. A guarantor is similar. They guarantee the payment to the bank, but only after the guarantor, or the co-signer, or the actual borrower failed to make payment. So those agreements are between the guarantor, co-borrower, and the bank regarding the payment of the loan. Nowhere in those documents do they give title to the property. When a loan is paid off, I think a comment was made, when a loan is paid off, the bank doesn't actually give title to that property to the borrower. All they do is release the lien that they have on that collateral. The title work is what gives that ownership, not the bank. They just release the lien. Other than that, as far as administering this bill, it's fairly simple. We just need to make sure that our banks, if this passes, has this disclosure in their existing documents. But for clarification, for my purpose, for my own interest anyway, I just had a few questions as to the intent of the bill and what problem it's trying to address. Mainly just, is this an isolated incident or is it systemic? If it is systemic, that's something I'd like to know about for other reasons. And then this confusion of who owns title, obviously this is a problem from the sounds of it. Was this confusion driven by the bank, or was it just someone who didn't read the document they signed? I'm not sure. I'd like a little bit more information as to what is the actual problem here and how widespread is it? But with that, I don't have any other comments, but I'd be happy to take any questions.
Thank you, Commissioner Bishop. Senator Boner.
Okay, and along those lines, Mr. Chairman, if somebody co-signs on a loan, is that generally a part of the paperwork saying, you may be making payments at some point on this loan, but at no point under the current agreement will this property ever become yours? Is that clear if they actually look at the documents?
Commissioner Bishop.
Mr. Chairman, thank you, Senator Boner. I'm not sure if that's actually stated in every single co-borrower or guarantor agreement. I am not sure of anywhere else in the agreement it does say that this gives title to anybody. I'm not sure if it actually expressly says that, but I do know that the bank, that guarantee document cannot give title to somebody, so I'm not sure. That's why it doesn't expressly say that, it doesn't either.
So, anybody else? Commissioner, I'm not sure I know how a loan works on a vehicle because all my vehicles are so old I don't have loans on them. But with a house, of course, you know, real property, there would be a warranty deed filed, and then there would be a lien registered, but it'd be clear from the warranty deed who owns that property, right? Now, for a vehicle, I assume that the title of the vehicle is titled to the individual, but again, there's a lien on it. Once again, it's clear from that title who owns the vehicle. Would that be fair? I mean, in your opinion?
Yes, thank you, Mr. Chairman. Yes, in my opinion, generally the title, or if you have a car loan, there's a title, it's in the, you know, the owner's name. And if it's the loan on it, there's a stamp at the bottom saying first lien, second lien, third lien, and the bank's name's on that first lien. That just means they have a lien on that title because it's tied to a specific loan. There's usually a dollar amount also, and it's very similar to a mortgage.
Right. In no instance would the cosigner automatically be on the title for the vehicle or the deed for the property. I mean, it's possible that they could own it in joint tenancy or right of survivorship. I mean, there's different things they could do, but they don't, there's no automatic that cosigner would be on those notes.
Thank you, Mr. Chairman. That's my understanding. And I would say there are other ways the cosigner could be on that title. However, the banks would not put their name on that title.
Gotcha. Anybody else? Senator Landon. See, I got those brain cells.
Thank you very much.
working.
Yeah, it's a Tuesday on a Monday or vice versa. So Commissioner, does this bill create, I thought I heard you say that it can be administered, and from your standpoint, does it look doable, and does it do no harm, I guess?
Commissioner.
Mr. Chairman and Senator Landon, for our administration of it, that's just all we would do is we look at loan files for creditworthiness. One thing we would do is check loan files if this bill passes to make sure that the actual guarantee or borrowing document has this disclosure language in there. That would not, it doesn't take very long for our examiners to check on that. So that in that respect, it would be fairly easy for us to check compliance for this statute if it were to, or this bill if it were to pass.
Okay, thank you.
Anybody else? Thank you very much, Commissioner. Stay close. Mr. Meyer, were you hoping to talk to the committee about this bill? Mr. Meyer.
Mr. Chairman, members of the committee, Scott Meyer on behalf of the Wyoming Bankers Association. I don't even know where to start on this bill. Philosophically, banks don't want to be the gatekeeper. We don't want to be the first in line. We have nothing to do with the transaction when it comes to ownership. I think has already been discussed, banks and other financial institutions may lend money, and most likely they will put a lien on that property, whether it's through, as this committee is well aware of, we have as of a couple of years ago, we have a new vehicle lien statute. So that deals with putting, like on personal property, on titles to cars, but we also have mortgages, and to some extent in Wyoming, although not very often, we have deeds of trust. But those are all instruments that they do to secure the loan that has been made by pledging that property as security for that loan. The loan is a completely its own transaction. It does its own thing with the lender. The lender says, here's my promise, here's your promissory note, you're going to pay me, but if you don't, then here's what we have as far as collateral. And with banks, they look at three different things. I call them the 3 C's. They look at, do you have the capacity to repay? Do you have the collateral to secure your loan, and are you of good character? So those things that you look at, you say, okay, that's driving the loan. With respect to this particular bill, now you're asking, well, let's make sure that people know. Well, there's a lot of things we can make sure people know, but I don't think it's the financial institution's job to make sure of that. That's why they have a lawyer. That's why they talk to people who are involved in this. It's not the financial institution's responsibility. We're just in there for the loan. So you look at this and you say, geez, Dad lent the money, Junior defaulted on the loan. He should know that he doesn't have an interest in that property. Well, that's not the bank's job. And by the way, you could put that in there, but it really does complicate things a little bit. You know, the loans that banks and other financial institutions use, the paperwork that we do with that, long gone are the days when I used to make a living drafting up loan documents. They're all done by Laser Pro. They're all hired out, whatever. So now you have to go back and change that form. You've got to make sure all your forms and stuff. It's not a big thing. It really isn't, but it is a thing. And you're now changing up the system because somebody didn't understand how that works. Somebody didn't talk to their lawyer. Somebody didn't figure out why the loan is. If they're a guarantor, it's one thing. You certainly want to know what your rights are if you're making that guarantee on a loan that somebody's going to pay it. But as a co-signer, you're involved in this thing. You know everything that's there because you're a co-borrower. You might even be on the property itself, but maybe not. But that's why I say that's where it's important that you understand exactly what you're dealing with. And I don't think it's really the financial institution's job to make sure that you, as a guarantor, understand everything. I mean, you're deemed to understand the contracts or the agreements when you sign them. So if you are there, fine. If you have questions, you have the opportunity to seek legal counsel or anything else, anybody else that you want. But the documents are the documents. And the loan is the loan, and that's separate from ownership, and I think is brought up earlier. The title to the property is on a deed. The title to your car is on a title. Those things are the evidence of ownership, and the lending institution has nothing to do with those. We make sure that you own it if you're going to pledge it, but we don't make sure anybody else has ownership later on. The other thing I'll bring up too is the fact that, as I think the commissioner brought up, you know, his responsibility as head of the Division of Banking, and they have requirements that they have to do, and they regulate Wyoming's charter banks, and that's fine. This bill says no. If you look on lines, I believe on line 6, on page 2, it says the financial institution shall. Well, this legislative body and the governor can make sure that there are laws that grant financial institutions more powers than they might have, but they can't require anything that's not a state charter bank. How many loans are out there with respect to Quicken loans, credit union loans, other lending institutions that are out there that are not chartered, you know, the big banks that are not chartered in Wyoming? This law is not going to have any impact on them as far as I'm concerned. And so now you're going to single out Wyoming charter banks to make sure that they do this, while other banks don't have to do this because this law won't have any effect on them. So I just don't think that this law is, I don't think that this bill is good. I think this bill is, as I read it, is intended to fix a certain situation, somebody that is not understanding how things work. I think that we were better off served to have those customers and those constituents talk to their legal counsel before they start co-signing on bills. And we stand in opposition to this bill. Stand for any questions.
The trouble with Mr. Myers, you're never really clear where he's coming from. Are there questions for Mr. Meyer? Senator Scott.
Mr. Chairman, a lot of what I hear is you're saying that the cosigner ought to get their lawyer to tell them what to do. And Mr. Chairman, it seems to me, and I'd like to have Mr. Myers' take on this, that that's all very fine for the very wealthy end of the population. But for most of the rest of us, frankly, our system of justice is priced out of reach of the average citizen. And they don't have a lawyer, especially when you're talking car loans and even some of the real estate loans. They simply don't have a lawyer. That's not the source of finding things out. And it seems to me this bill is trying to say, look, people are getting burned. And the best way to educate them on what their rights are and aren't is to use the banking system to tell them, because they're, as a realistic matter, they can't afford a lawyer, and you could get me going on the troubles of our legal system and how wealth is what you need in order to use it. Why isn't this a good place to put that kind of requirement?
Deep breath, Mr. Meyer.
Mr. Chairman, Senator Scott, I would tell you that this particular bill, if it were to become law, would say, by the way, you need to check with your lawyer, because they're saying you don't necessarily have an interest in this property. We're letting you know ahead of time, so now you have to go figure it out. If you're co-signing on a loan or you're guaranteeing a loan, if you don't have understanding of what you're doing on that, then you probably ought to be checking with a lawyer. And by putting something in there that says you need to go check with a lawyer, you haven't saved yourself any money. You've just now had somebody point out to the fact that you need to go see a lawyer. So I'm not sure it's a cost issue. It's just who is the one that needs to point this out? And like I say, your charter banks may not be doing a lot of the mortgages. They will do some. But some of these are mortgage mills. You go down to mortgage company down on Lincoln Way, and you can get your mortgages, and they're not chartered by state of Wyoming. So I don't know how you're going to require them to do any of that.
Senator Boner.
Thank you, Mr. Chairman. Do you think that someone would necessarily have to have a lawyer to figure out what co-signing means, or would a simple internet search suffice, Mr. Meyer?
Mr. Chairman, Senator Boner, I don't know that you need to have a lawyer. I think that what they're trying to say is they're trying to alert the fact that you don't own an interest in the property if you end up paying the loan. And like I say, it's not a big deal. It's just I'm not sure how you're going to pick and choose where people are going to go, because I'm not sure that, all you get is the chartered banks. So I don't think it addresses that issue. And second of all, I kind of think that if you're guaranteeing or signing on a loan, then you understand. I mean, you got to understand what you're doing. I don't know anybody that willy-nilly just signs them, but perhaps.
Further questions for Mr. Meyer? Mr. Meyer, I might have a couple. So we do have consumer protection laws that apply to all transactions in the state. I don't think they're in Title 13, but so you're saying Title 13 just is state chartered banks, right?
Mr. Chairman, that's correct.
Yeah, so there are unfair trade practice acts and things that would be of general applicability, maybe would be a better place for this to go, but would apply to all transactions possibly.
Mr. Chairman, I would agree that it just doesn't belong under the banking statutes.
Okay. Can I ask another? All of us are seeking free legal advice today. Not really, but if we have a cosigner on a loan, say that I cosign for a loan that you're obtaining, and then you end up defaulting, and then I pay it off, but then we get all done. Do I have a civil cause of action to take you to court to recover my money or not?
Mr. Chairman, I do believe you have a civil cause of action, and if you paid off something and you have not received anything in there, then now you have, you've received, the other side has received a benefit to which they are not entitled.
So we could go to court, and the court could come up with different ways of settling this, award me a cash price, right?
Right, Mr. Chairman, that would not be under the court of law, that would be under the court of equity. And there's where I think that the judge, whoever that might be, would say, okay, you've received this benefit to which you've not paid for anything for, and now how are we going to equalize it? So it could be a cash payment, it could be an interest in the property, it could be whatever the judge believes is the most fair way to deal with it.
And the judge could grant the property itself, couldn't he?
The judge can do pretty much anything he wants, Mr. Chairman.
Right.
Or she.
Thank you. Any other questions for Mr. Meyer? Thank you, Mr. Meyer. Anybody else in the room want to testify on this bill? Is there anybody online that would like to testify? I think they're all from Bondurant, actually, is what I. Okay, let's close public testimony. Committee, you've heard the testimony. What is your pleasure? Got a motion by Scott. Discussion? Any proposed amendments?
Mr. Chairman?
Senator Landon.
I appreciate the discussion this morning. I'm trying in my mind to flip the coin a little bit. thinking, I'm not sure the bank always knows when you go in to borrow money, you secure the loan by collateral or whatever you put up to. And I'm not sure the bank really needs to know what you're going to use the money for. I'm not sure they always do necessarily.
Or they might have an interest in whatever it is. If it's real property or a vehicle, I guarantee you the bank's going to have their handle on that somehow.
Right, yeah, good point.
I didn't mean to. Anybody else? Senator Barlow.
Thank you, Mr. Chairman. So I guess I'm most perplexed by the location of this in the banking statutes, and reading it, it's only applicable to state
charter.
organized banks, and national banks were specifically provided by the text. So this doesn't account for credit unions, it doesn't account for all the other types of lending institutions that are out there, and maybe you want to bring the sponsor back to address that, what I would call not just a gap, but a gaping wound in what this is trying to get to, Mr. Chairman.
So it's either the sponsor or maybe the banking commissioner. Is this a gaping wound? Who would like to address us? Okay. Thank you, Commissioner. What's left out of being covered by this, I guess is the question.
Yes, thank you, Mr. Chairman. Senator Barlow. So Title 13, it applies to state chartered banks. It does exclude credit unions and national banks. There are also other lenders that are not in Title 13. So our office also oversees consumer lenders. That's under the ECCC, the code, and the Mortgage Act. Those are all, I think, I can't remember this exact titles those are in, but it's not 13.
How many state chartered banks do we have?
Mr. Chairman, 23 at the moment.
So 23. That's what this would affect. Thank you, Mr. Commissioner. Do you want any last words? Representative? Is this a committee bill? Is it? No. Oh, we won't give it special treatment then. That's just inside joke.
Chairman, last words, really, that bothers me just a little.
Okay, go ahead.
So I just wanted to point out two things. The intent of this is on page 2 shall be provided by the financial institution. And of course, the title where this was put was LSO choice to that. And so there might need to be a
Gotcha.
change there. The other thing that I would point out is that by providing information, I mean, I've thought about loans that I've co-signed on, you're trying to help a friend or a family member or something like that. Actually, information might be helping to avoid legal issues. And so again, this isn't, not trying to put anybody on the hook, just a point of information.
Yes, and thank you, Representative Jennings. I think maybe one concern we have here is that you're only reaching 23 financial institutions, and there are probably 1,000 of them out there. And so, yeah, did that come up on the other side? Your side?
Mr. Chairman, it was talked about, again, the intent on page 2, 6 and 7. The disclosure shall be provided by a financial. We didn't want people who were making a loan amongst family members or friends or things like that to be burdened at all with any of that. We were just looking for, and there was a little discussion to that, but not much.
Senator Scott.
Mr. Chairman, is financial institution a defined term?
Mr. Jennings.
Here, Mr. Chairman.
Yeah.
Senator Scott. There is I believe, a definition. I believe it did come up.
Senator Scott, do you have any follow-up? Senator Barlow?
Thank you, Mr. Chairman. So Title 13, 101, financial means a bank, savings and loan association, trust company, or state chartered credit union. Which I don't know how that fits in the, I don't know what any of those except a state chartered bank fall under the commissioner's purview.
It sounds like from the commissioner's testimony, it's only 23 entities. So, Senator Scott.
Mr. Chairman, with that definition, I think it's broader than just those 23 but I think there may be enforcement problems.
There'd be some lack of clarity in the statute if somebody were trying to reach into banking statute
Yeah,
to apply it to some other entity.
Mr. Chairman,
Oh, here comes the commissioner again. We've got him riled up today. Have a seat, Commissioner. Thank you, Representative. You can stay right there. Commissioner,
Thank
can
you,
we
Mr.
reach
Chairman.
into this statute and tag other entities? It sounds to me like we probably couldn't, but to you.
Thank you, Mr. Chairman. So just a little clarification there. Senator Barlow did look at the correct definition of financial institution, and that says a bank, and it lists the other entities. We do not have any state chartered credit unions. We don't have any state savings and loans associations. So the only entity under that definition that we have is banks, and that's where those 23 entities come from, and it does exclude national banks. So these other institutions, such as auto dealers, those fall under a different section of code.
Right. Okay. Anybody else? Any further discussion on this bill? Senator Scott, thank you, Commissioner.
Chairman, what it sounds to me like we've got a bill that achieves part of its purpose, but really doesn't reach some of the people that it intends to. And
I think that's fair.
I think probably you have a miscommunication between the draft, the sponsor of the bill and the LSO in terms of how it ought to have been
It's
drawn.
applicability.
And I think possibly this is where we're paying for the degree of turnover we've had in the LSO.
Well, I'm not sure about that, but Representative Jennings, so you see our quandary is that we think this only applies to 23 entities in Wyoming. And we think probably you meant it to apply more broadly than that. Yeah. So,
Correct, from page 2.
yeah.
We wanted it to be financial institutions, which,
Mm-hmm.
again, Senator Barlow pointed out the definition and
So this didn't come up on the other side, though.
not to this depth. no,
Yeah.
sir.
You've had a bad day to walk clear over here to the Senate side. I'm sorry about that. Further discussion on the bill? Further discussion? How about calling the roll on the bill, please?
Senator Barlow?
No.
Senator Boner?
No.
Senator Landon? No. Senator Scott?
Aye.
Mr. Chairman?
No. But thank you, Representative. There are a couple other places I might suggest you might put something like this. And there's unfair claims practices, which is of general. Representative Stith there would know a couple places where you could do it too. So thank you very much. Good luck. All right. I think we're ready for the bill that everybody's been waiting for. House Bill 270, engrossed improvement and service districts limitations. Is that Representative Northrup? Welcome.
Thank you, Mr. Chairman.
Welcome, and tell us about your bill.
Thank you, Mr. Chairman. This is a bill about service districts. The closest that I can relate it back to in my world is an irrigation district or a ditch company. Ditch company comes out and says, for example, we'll charge you $30 an acre for water. And as they're going through the year, they decide that they need more money because of the budget and inflation and everything else that goes on. So what they do is they come back and have a meeting and turn around and add another $25 assessment fee for every contract that they have. Well, a contract in my case in the district was every 80 acres that was originally put together under the Homestead Act. So in service districts, some of these especially service districts, as you can see in this bill, when you turn to page 2, there's a limitation on line 11 that on that maximum fee and charge. So originally you had a contract as in my irrigation district where you had a $30 fee, and then they turn around, so that's the original fee, the maximum fee. So that has to be taken to the county commissioners, that money, then the county commissioners say is worth X number of mills. And that's what little I is. And they come back and assess that on your taxes. And then so shall be approved only to that district as created under this statute 18-12140. Turning to page 3, you'll see that on 3 little i's may be eliminated, reduced, or increased if approved by a majority of the qualified voters. In other words, you need to take it back to the people who are going to be affected by it and say, please notify these people and let them know what's going to happen. And then that goes up to a ballot so that at least they have input into it. Now, in my case, if a canal broke, for example, and it's going to cost $25,000, $30,000 to fix the canal, as in fact, as we know, it's lots more than that in the case of what happened in one county, then you have to come back and assess a special fee. And somehow you're going to have, that company's going to have to be able to take a loan out and work it out and make things work so that they don't, first of all, run out of reserves, and yet everybody's going to have to pay their fair share. So at any rate, in C, any district taxpayer or repair of any district charge the assessment and may bring suit. So that's just giving them recourse. That gives the people who are being charged that a chance to have recourse if they don't agree and it gets passed through. So if you go down to the bottom on E on page 3, line 19E, the prohibition in this section shall not apply to fees, charges, mill levies, taxes, or other assessments in this district has been organized without a petition, because as we talked about in the House, there could be some grandfathered in old ditch companies or old service contracts that never had anything. It was an agreement between gentlemen, and they just had this understanding that it was going to take this amount of money to make this work. And so we grandfathered them in. That's the amendment that was on the House, just to be sure that everybody, that's why it's an engrossed bill.
Okay.
And other than that, when you turn to page 4, you'll see that the new language on the bottom of the page, the board shall not adopt any rule, regulation, or procedure without any fee, charge, or mill levy, without a tax or assessment. And you, of course, you can read the rest of that yourselves. So what we're trying to do is service districts, where they are, they need to have input from the people if they're changing the dollar amount that the original contract was. They need to be able to have a vote on that, and they need to notify them. So that's why the vote on that. The other part was you need to be able to come back in and have a recourse if for example, it turns out to be a horrendous charge. And instead of turning around and saying, we need to get a loan on it and work this loan out as an irrigation district when the canal breaks. So that's the recourse on it. And I guess I stand for questions after that.
Okay. Any questions for the representative? Senator Scott.
Mr. Chairman, on page 2 at the bottom, shall apply to all local improvement districts created under, what are those? What's the list of all of them? Is that your local paving improvement district, whatever they call
Well,
those things?
I pulled that.
Representative Northwood. And I might point out that you have a friend in the back row that we could bring back. He's actually from the second row, but we might bring him up too. You're a co-sponsor,
Okay.
if that's all right. But you go ahead. But he had his hand, he was waving very
was waving his
vigorously.
hand.
You didn't see that he was trying to get your attention.
It's hard when they're behind you, so.
Yeah. Anyway, go ahead, Representative Northwood.
Thank you, Mr. Chairman, and excuse me for blurting out because I'm used to just blurting out. So anyway, 1812-140, I pulled that statute and wrote it down. It's actually, it just refers to special improvement districts, created local improvement districts in a district organization pursuant to this chapter. It does not list it, and I'm sure that my compatriot and his co-sponsor can answer the exact question.
Representative Stith, welcome.
Mr. Chairman, thank you very much. This bill applies to service and improvement districts created under Chapter 12 of Title 18. So it applies to service and improvement districts. It would not, there are there's a whole laundry list of special districts, obviously, cemetery districts, flood control districts, senior citizens districts. This only applies to service and improvement districts under Chapter 12 of Title 18. And as Chairman Northrup, I think, explained, what the background, and this bill language is probably familiar to many of you because this bill language is virtually identical to a Joint Corporations Committee bill from 2 years ago, I believe, when Senator Landon was chair of the committee and Senator Scott also served on that committee at that time. So the bill language is virtually identical to a bill that was approved by the Joint Corporations Interim Committee 2 years ago. There's one other difference in this bill is that the House placed an amendment to state that if the board wants to, say, raise the mill levy, for example, and they have an election, it's that a majority of qualified voters casting ballots, so that, and that was to address a concern that you might have landowners who, may be hard to all get in a room and vote. And so it doesn't have to be a majority of all of the landowners in the district, but rather just a majority of those casting ballots. And this does, and as you may also know, would legislatively overrule a decision of the Wyoming Supreme Court that came out in 2021, Winnie versus Hoback Ranches. I was counsel for the plaintiff in that case. And in the House, I voted conflict on this, not because I don't own land in a special improvement district. I'm not sure I have a legal conflict, but I've been pretty closely associated with this issue. The Supreme Court said that because service and improvement districts do not have any statutory cap on the mill levy at all. They're the only kind of special district that has no mill levy cap, that the landowners, when they formed it, were not allowed to place one. And this bill would state that no, landowners, when they make the decision to form a district, have the right in their organizing petition to say, we don't want our taxes to ever be above X level, 8 mills, 10 mills, 12 mills, whatever that might be. But then the bill, as you can see, also has the escape valve to say that, well, circumstances change and a majority of the landowners casting ballots do want to increase or frankly reduce the mill levy, they would be allowed to do so.
Okay, thank you very much for that. Questions for either one of these gentlemen? Senator Landon.
So, thank you, Mr. Chairman. So probably for Representative Stiff, just on the legal side of things, it looked like there was quite a bit of debate on your side. And did it come down to the flexibility of a special district being able to do whatever they wanted versus, no, we need a bit in the horse's mouth a little bit? Am I characterizing what the discussion was on the other side?
Representative Stith.
Chairman Case, Senator Landon, that's correct. And the idea is how much do you trust the board of, in some ways that's a policy choice of how much do you trust your board of directors of your service and improvement district. And that's kind of the policy choice to make here. Yeah. This bill does not impose a cap on taxation. It just says that the landowners, when they form the district, have the authority to do so if they so choose in the petition for formation of the district.
Okay, thank you for that.
Anybody else? And Representative Stith, actually, Senator Boner and myself were also on the committee. So you're just speaking to your old speaker here. That's, we remember this bill very well. So thank you very much. Any other questions for the sponsors? Let's hear from the public on this. Oh, we got one more question. I'm sorry. Senator Barlow.
Thank you, Mr. Chairman. Thank you, and I apologize. So this is based on the initial document, and I'm not going to come up with the right name, original petition, but the county commissioners also have a role in this because that petition actually goes to the county commissioners. So is there the occasion that a petition is what is approved, the resolution, or I guess it'd be a resolution from county commissioners, is not in the same form or the same outline as the petition? Thank you, Mr. Chairman.
Representative Stith?
Chairman Case, Senator Barlow, that's in fact what happened in the Hoback Ranches case, where the initial petition limited the landowners in the petition said, please limit the mill levy to 8 mills. But when the county commissioners adopted the resolution that actually formed the district, it was silent about that. And the Wyoming Supreme Court said, well, the county commissioners left that part out, and so it did not become a binding feature of the district.
Mr. Chairman.
Go ahead.
Mr. Chairman, so a follow-up. So what is being voted on by the voters when they do actually, the landowners, actually landowners by statute is a little different than electors. There's a nuance in that. But what is being voted on? Is it the petition, or is it the resolution that's being voted on by those folks, informed folks, when they form this, officially form this? Thank you.
Representative Stith?
Chairman Case, Senator Barlow, the in some ways, it's not quite either, because the resolution that forms the district happens after the election. That is, the election occurs, and if the voters approve the formation of the district, then by resolution, the county commissioners are obligated to formally create the district. So the petition is the request, then the question is put on the ballot. In this particular case, the ballot language itself was lost. It was never discovered. The county clerk couldn't find the ballot language, so no one knew what the ballot language said, which was just an oddity of that particular case.
Anything else? Senator Landon and then Senator Scott.
So just for clarification, Representative, that clarifies for the county commission and commissioners out across the state that this bill just gives a little further guidance. Post-election, they pass the resolution, create the district, but this is a reminder that there are going to be limits, and then they're going to have to come back to you as commissioners if they want to change what they're up to. Am I reading that correctly?
Representative?
Chairman Case, Senator Landon, I think the way this bill is structured, it would be up to, if the district is formed and the petition does have a limit on taxation, and then the board later wanted to change that limit, then there's an election process. And the county commissioners really would not necessarily be a part of that. And it's really analogous to an existing amendment to the Service and Improvement Service District Act that was done, I believe, in 2015 or so. It was Representative Kirkbride at the time who brought an amendment. It's now codified at 18-12-141 that says that districts are not allowed to provide services that are not listed in their original petition. So that already exists, that they can't provide additional services. This, in my view, kind of completes the picture and says, oh, without a vote, this completes the picture and says, okay, if you can't provide new services without a vote, this would also say, well, also, if you want to raise their taxes, you have to ask the voters for that too.
Yeah, thank you for that.
Senator Scott?
Mr. Chairman, I've noted that looking at my email pile, and the significant part of the 4,000 I'm behind was coming out of Bondurant, and they all seem to be again this bill, and seem to think it was a special interest thing aimed right at them. What's going on? I don't understand what's going on there and what the source of the opposition they have to this is.
And I think we should preface this by saying what it's astounding words we just had, that Senator Scott admitted that he looked at his email. To you, Representative Stiff.
Mr. Chairman, I do that routinely, but I'm focused not on people from Bondurant, but on people from Natrona County that elected me.
I know. Representative Stiff.
Chairman Case, Senator Scott, I suppose in fairness to the residents in Bondurant who are against this bill, obviously they can speak for themselves.
And we have several online. So.
But my guess is they would say something like, well, we elect our board of directors and we trust them and we think they're doing an okay job. This bill is of general application, and there are hundreds of service and improvement districts across the state. It would not apply just to one service and improvement district. It would apply to any service and improvement district. And there's also, I think, of the formation of future districts, because what the Supreme Court has done actually is really chilled the creation of new districts, because the Supreme Court has now said, you landowners, you can form a new district, but you have no control over the taxation, because the taxing power of a service and improvement district is unlimited. And I think going forward, that would have a chilling effect on the creation of new districts.
Thank you. Anybody else? All right, let's go to the public on this. Is there anybody in the room that would like to testify on this bill? Is there anybody in the room? Mr. Winnie?
Mr. Chairman, Bill Winnie, Sublette County. In my view, I just remark that this bill is about transparency, about going back to the voters if you want to change things. And there's a lot of smoke and mirrors out there. But that's the core of the bill, and I'd appreciate the committee's consideration. Subject to your questions, thank you.
Thank you, Mr. Winnie. Any questions for Mr. Winnie? Senator Barlow?
Thank you, Mr. Chairman. So one of the bill co-sponsors just said there were hundreds of these districts out throughout the state. But I think that was what I heard just now, hundreds of these districts. So what level of communication has there been with these other districts regarding this general applicability, even over 5 years? If this bill has been in the works for 5 years, I think I heard that earlier, or several years as a committee bill, what has been, what has come from that understanding for other districts, from other improvement districts? Thank you, Mr. Chairman.
Mr. Winnie, if you can, I mean, that might be a better question for the co-sponsors, but go ahead.
Well, Mr. Chairman, I can shed a little bit of light. Representative Stith asked me to call up other districts and ask about things like the tax issue and whether this bill would affect them if they would have had to have had a cap in their formation documents. And I called probably about 60 districts and asked those kind of questions, and they had no impact on those districts. They seemed to say that, well, yeah, we would go back to the voters if we wanted to change things. Subject to questions. Thank you.
Thank you, Mr. Winnie. Anybody else? Anybody else? Let's go online and let a couple folks in and let several in as far as I'm concerned. How many do we have to testify? Okay. And Molly Nimitz? Okay. Let's just see who gets here first. Mr. Lasenek, am I saying that right?
Listenik, sir, yes.
Thank you, Mr. Lasenek, sorry. Please go ahead.
Chairman, senators, thank you for your time. I appreciate it. I've submitted a letter to all of you, which I will hope that you took the time to read. I will focus in just on one part of that letter. And that is to examine what the intent of the Improvement and Service District lack of a mill limit might be about. As has been mentioned already, there are a number of types of special districts. There are over 25 of which I examined. And in this case, 15 of them had mill limits explicitly. The other 10 did not. And I would argue that that's not a mistake. It's not an oversight, that those were put together intentionally, that it was done on purpose. And I think if we look back up and looked at why might that be, that there are several things we might consider here. One is that the officials are elected that run the Improvement and Service District, that there is a remedy if the board is not fulfilling the charter and if they're violating the will of their constituents, that remedy is to vote them out. There is direct representation. There is a high level of engagement by the folks that participate in meetings around the Improvement and Service District. The other thing I would point out here is that there does seem to be a theme across the special districts that do have mill limits. Not all of them, but one of those themes is that they tax everybody under their purview, even people that do not use the services that the special district offers. And in that case, I think it makes good sense as a matter of policy to limit the burden on the taxpayer and put a mill limit in place to say, okay, not everybody uses this, but we're taxing everybody. Let's put a limit so that we maintain it as a reasonable thing. In this case, in an Improvement and Service District, every member that's taxed gets a direct benefit and enjoys the benefits that the Improvement and Service District offers. So that's really important to consider here. It's been mentioned a couple of times that the board can just raise taxes and there's no limits on that. I would say that's a little bit misrepresentative of how the process works within Improvement and Service Districts, because there's actually 2 rounds of public meetings in which a budget is presented and discussed with constituents, open to the public, before it's sent to the commissioners to incorporate and turn into, paperwork that they use to send out tax notices or assessments. That budget represents what the people of the Improvement and Service District want. There's lots of opportunity for people to engage directly about what they do not want. All the numbers are there for everybody to see and vote on. And so in that way, it's not just uncontrolled, unmitigated. Excuse me, my dogs are barking in the background. I hope that's okay.
We don't hear
Not
them.
uncontrolled. Okay, great. It's not uncontrolled and unmitigated. There's a process that's very open, very transparent. Improvement and service districts have a lot of variability and unknowns. As we heard, there's hundreds. They have very different needs. And those needs are here in the Improvement and Service District I sit, in Bondurant, we had, for instance, the Roosevelt fire. That cost us tremendous amounts of money to deal with. Fortunately, we had grants and things like that, but it just goes to show that there's variability and you don't always know what you're going to have to deal with. That took a lot of work on our roads and our fences. The last point I'll make is just that the critical nature of the services offered by an Improvement and Service District are different than a lot of other special districts. And that's not to say that the other special districts are not important. They all serve an important role. But here with Improvement and Service Districts, we're talking about the fact that my property rights, my ability to get to work and get home every day, my ability to meet my basic needs associated with my property are totally dependent on the work of the Improvement and Service District. The ability in this bill for an individual to bring lawsuit, a single person, which has changed, it used to be 30%. Now it's changed to a single person in this bill, to sue the Improvement and Service District continuously, leaves this kind of open door for an expense that the Improvement and Service District will have to pay, defending itself in lawsuits, while capping it. What's that mean? That means that could put an Improvement and Service District in a financially ruinous position, unable to fulfill its charter, its duties, unable to really help the people maintain their property rights and enjoy their properties in that Improvement and Service District. So I will leave it there and say thank you for your time.
Thank you very much, Mr. Losinek. Questions for Mr. Losinek? Questions? I might have one. When you mentioned the budget is voted on, who votes on the budget that in your testimony when you mentioned that? Is that all the members of the district or is that the board?
Chairman, thank you for the question. It is not all the members of the district. It is the board. I will say in my experience, that has been a highly engaged process where folks do have direct influence. But yes, you're correct. It is the members of the board that vote on the budget ultimately.
Thank you very much. Anybody else? Thank you, sir. Now we'll go to Ms. Nemitz. Am I saying that right?
Yes, you are.
Welcome, ma'am.
Thank you.
Go ahead.
Thank you, Chairman Case and members of the committee. My name is Molly Nemitz, and I too live in Bondurant. I have some familiarity with the Improvement and Service District statutes because my husband and Dave and I bought property over 40 years ago in what has now become a large service and improvement district. At that time, I happened to be on staff at the LSO and actually worked on drafting some of the special district legislation, including improvement service districts. So after we retired here, Dave was elected to the board. And so because of these experiences, I believe that House Bill 270 is very disruptive of the statutory scheme that was set forth in the Improvement and Service District Act and will muddy a process that the legislature has worked for years to clarify. And so, as you know, the improvements and service districts are governed by primarily by three different acts. The Service and Improvement District Act, Title 18, Chapter 12, the Special Districts Election Act, which is Title 22, Chapter 29, and the Public Records, Meetings, and Financial Administration Act, which is Title 16, Chapter 22. So it's pretty complicated. And service and improvement districts were created in the 1970s to basically provide self-services to subdivisions when the county was unable or unwilling to provide them. So the formation process starts by the filing of a signed petition with the county commission. So these petitions of formation, which is the determinative document in House Bill 270, originate with the developers generally, and they're trying to relieve themselves of the financial burden to provide services and yet still show a level of maintenance to attract further sales. Understandable. The developer, or as he would be called, the chief petitioner, must convince 60% of the landowners owning 60% of the property to sign. Now, think about it. The petitioner wants to get rid of the burden to maintain this subdivision and pass it on to the landowners. So he's going to basically request anything that might entice 60% of the landowners to sign. He could say the streets are going to be paved in gold and we're going to make bridges out of granite. They'll never fail. And that'll only cost you 4 mills. But once a valid petition is filed, it obtains enough signatures, the county commissioners then have the authority and the responsibility to hold a public hearing and consider the petition. Specifically, Wyoming Statute 22-29-109, Section F approves that if, after the public hearing, the Board of County Commissioners, within their authority, decides to approve the petition as presented or modified, and that language is in the statute, the commission by resolution presents the issue of formation to the electors of the district for ratification. So what the Supreme Court and affirming the district court decision in Winnie versus the Hobeck Ranches was that the county commission, through a resolution, and not the unaccountable non-governmental petitioner, is who establishes the district and decides the terms and conditions, that those will be and presents those to the voters for ratification. And this was upheld by the Wyoming Supreme Court, as I mentioned, and did not, as I think was mentioned, say that the petitioner or that the landowners could not place a limit. It was just that that limit must be placed by the county commissioners and then voted on by the prospective voters in the district for ratification. So that is the biggest problem that I have with this bill. And in addition, one of the, back I think in the interim committee back in 2020, there was a comment made by one of the sponsors that the taxpayers need some sort of a surety about taxes. Well, it's not the petition for formation that's the legal document that's filed in the county records. It is the county resolution that is filed in the legal document land records, and that's the only document that could really provide notice to the to future purchases. So I would strongly urge you, if you're going to move this bill forward, that you must substitute the county resolution establishing the district for the language original petition for formation, or it's going to create all kinds of chaos and confusion, because the Supreme Court has ruled that that petition of formation, and I can cite the language, has no legal effect. So I would encourage you to amend it to the county resolution establishing the district. However, there's one other part of the service and improvement district statutes that this bill would disrupt, and it concerns me greatly because it's a very useful tool in the toolbox for improvement in service districts to use to protect taxpayers. Wyoming Statute 18-12-115 through 119 allows the district to provide services and improvements to certain parts of the district benefited more than other parts, and then assess those taxpayers accordingly. For example, this current statute allows that one part of the district might want dust control on their road and nobody else really cares or needs it. So what the special assessment, there's a process by which the board of directors could go in and these residents could request this special service or improvement, and they could be provided that, and they and only they would have to be assessed that. But House Bill 270 would negate this special assessment process because of the aggregation component. No one taxpayer could be assessed more than this limit, even if they wanted to be, unless the overall budget was significantly reduced. And it's important to note that this statute already provides that in this special assessment portion that there's a specific objection process. And if 30% of the people included in this special assessment don't want it, then the special assessment cannot be authorized. So that's a big limit that really helps shift the burden of taxation to the appropriate members. There was also like road impact fees. The Supreme Court and affirmed the district court's ruling that those were perfectly legal under the Improvement in Service District Act, and road impact fees would be when you would assess damage to the taxpayer that's new construction, so that they're paying for the damage to the roads instead of everybody else. So these are an important tool, and I ask that you please don't arbitrarily remove this flexibility from the Improvement in Service District statute. So I ask you to oppose it because it can cause confusion and chaos and legal expenses for residents. It will hamstring the district's board's ability to be good stewards of district revenues. Instead of protecting taxpayers, it's going to cause uncertainty. They have to provide, ISDs have to provide essential services, and they got to pay their bills. Budgets are set well a year in advance. And I also would encourage, if you do choose to go forward with this bill, that you do amend it to give any unsuspecting district that might be out there who has no idea about what's going on a chance to have another year to set their budgets before they have to start holding elections or figuring whether it's in the petition for formation or the county resolution. So I would seriously encourage.
Are we getting close to wrapping up, Mrs. Nemitz?
I'm done.
Okay. All right. Thank you very much. There was a lot there. So questions for Ms. Nemitz? Any questions for Ms. Nemitz? Okay, no questions. Who else do we have? Who's the next gentleman that's up? Mr. Haslam. Did you leave Fremont County and take up other residents? Welcome, Mr. Haslam.
Good morning, Mr. Chairman. Appreciate the opportunity to talk to you. Just briefly, I'm going to try to keep this as brief as possible. Just to answer a question that was asked earlier. There are 27 different types of special districts in Wyoming, meaning there are 650 special districts that are established in the state. Of those, 156 of them are service and improvement districts that have been established in Wyoming with elected officials, and most of those are all for specific needs. You know, as you well know, there are many different types of service and improvement districts out there. In the past, we have tightened up the process for special districts over concerns that have been out there in requirements such as education and reporting. Special districts were designed for local control of local needs. And as far as the Wyoming Association of Special Districts, we have not heard of any concerns from any other service and improvement districts about the concern that is being placed before you today. With that, I would stand for questions and ask for your vote against this House Bill 270.
Thank you, Mr. Haslam. Any questions for Mr. Haslam? You got off easy. Good to see you.
Good to see you. Thank you.
I think we have another one. Mr. Sumrall. Mr. Summerall, I can see you're muted. Can you hear us? Hello, sir. We're not hearing you. Now try it.
Yes,
There you go. We heard
how
you
about
for a
now?
sec. Yes, we can hear you.
It's been unmuted.
I think you,
Good morning, sir.
good morning.
Thank
Go
you
ahead.
for- Good morning. Thank you for coming up.
Sir, can you hear
Was
us?
factory up here, but in the area
Sir?
of the transmission.
Sir,
Yes, sir.
we're having really difficult, you're
I
cutting
can
in and
hear
out. Your internet's not helping us out here. We literally can't
Well,
understand
Kelly
what you're saying.
tells me that my audio's not working well.
Why don't you shut off your video? Let's start there, and that might free up some. Shut off your video. Turn your video off and try it now. Is he still there, Kelly? Let's hear if we can hear your voice without having to cram the video on the connection.
Is that,
Go for a
can
little
you
while.
hear me now?
Maybe. Keep going. Keep going.
All right. I'm currently serving as chairman of the board of service and I simply make a couple of comments without being redundant to some of the comments that have already been made. I've been the chairman of the board last 5 years, and we have a transparent system. Clearly stated, we have two regarding the budget that are open to the public, as Mr. Stick pointed out, and the budget is discussed, presented by the board, it's approved, and it's the commissioners who approve it. Our system is based on the Improvement Service District Act, is very transparent. We have oversight by the revenue, along those commissioners. In my opinion, I don't think this is a system issue. But I think it's obviously pointed. Ranch is evidenced by the fact that all of the public comment is coming from residents of Ranch. I also point out as it
Sir?
stands,
Sir, it's just not working. I apologize. We understand you're the chairman of the improvement district. And we tried just reading the words as they were coming out, but we cannot make out your speech. And I'm very sorry about that, but I'm going to cut you off just because we don't have communications. Yeah, but we understand that you're against
All
the
right.
bill, and there were some very good points made by some of your board members earlier, so it's very sorry, sir, but we just can't understand you. So we're going to say goodbye to you and appreciate it. Kelly, is there anybody else online? Okay. Anybody else in the audience? See, Senator Scott's out of the room, but I was going to seek a motion. Oh, we do have one more. Okay, Mr. Pepper. After Mr. Pepper, everybody, we're going to cut off testimony. So, Mr. Pepper, how about addressing the committee?
Can you hear me, Mr. Chairman?
Yes, we can hear you, Mr. Pepper.
Cool. Thank you, Mr. Chairman, members of the committee. Mark Pepper. I'm the executive director of the Wyoming Association of Rural Water Systems. We represent about 80 special districts, improvement and service districts that own and operate water and wastewater facilities throughout the state. We see this HB 270 as a disruptive bill and are opposed. As mentioned by several of the other panelists, too many issues to go into, but the primary one that Ms. Nemitz brought up was the petition is just that, a petition. It goes through the commissioners. It has to then go to the residents within the district that's being created in order to have the district actually formed. And at that time, there's probably I know in our case where we go in with water and wastewater systems, we make sure that everybody understands what's all going to take place and what the mechanisms for revenue generation are in operating some of those expensive systems. And as was mentioned earlier, also, putting in the legal remedy issue just muddles the issue in that it's almost like a public service commission deal, that you can seek to oppose a rate increase, but the utilities allowed to include legal fees in future rate increases. So if they do file a lawsuit, you just end up having to raise the rates or the budgets or whatnot in order to recoup those costs. And as was indicated, if by chance they have a cap, then you're in even world of hurts, and you could have a tremendous amount, in our case, water or wastewater facilities that could be have sustainability issues. So we are opposed to this bill for a myriad of reasons. Primarily, as Ms. Nemitz brought up, the petition is, and I'll liken it into possibly your language a little bit. The petition is kind of like a bill draft. And basically what this bill is saying is that if once it gets signed and put into law by the governor and there's been a bunch of amendments, if they weren't included in the bill draft, they have no force of law. And of course, the bill draft is not law until you all finally vote on it. So I think that this has a myriad of issues, and like Mr. Haslam mentioned, we have not heard any of these kinds of issues in any of the water and wastewater improvement and service districts that we deal with. And I think it's a local issue. If there's a problem with somebody in one of those districts, as to coin the phrase, that's what elections are for. They can always run for the board and go from there. We do advocate also, Mr. Chairman, that when those budgets are created, they're usually done so in a public hearing. They're done so in a public meeting. And we encourage as many people as possible to get out and come to those meetings to understand what's going to be happening. We also suggest that the boards send out a bunch of information prior to, so people understand what's going down the pike. And so I think the transparency issue is depends on the districts or whatnot, but as it relates to water and wastewater systems, I don't think that's primarily an issue. So we would be opposed to this bill. I'll stand for question.
Thank you, Mr. Pepper. Senator Boner.
Thank you, Mr. Chairman. Good to see you, Mr. Pepper. I'm just wondering, what has the bill's proponents reached out to you at all in your capacity at all? I was just wondering what has been your involvement up to this point? Just a little bit of background, maybe not too much. Just wondering how much involvement or input they saw from you in putting this piece of legislation together.
Mr. Pepper.
None. Thank you, Mr. Chairman, Senator Bonner. None. And I apologize for not being able to jump in on the House side. I was back east on the East Coast, testifying and meeting with another legislative body on national issues while it was working its way through the House. So I apologize that I was not involved in the House discussion.
Thank you. Any other questions for Mr. Pepper? Senator Landon.
Good morning, Mr. Pepper. Good to see you again. I guess my question is in regard to the charters and bylaws that are put in place by these special districts out across. How often do you run into a circumstance where you've got to go way beyond what was initially presented as to what it was going to cost a special district out there? I guess it seems reasonable to me that if that goes above and beyond what was promised, that it would stand to reason you'd have to take that back to a vote. Can you help me with, does that just never happen? Or if it does, there's not much of an uproar? You indicated that you hadn't really heard anything.
Mr. Pepper?
Yeah, Mr. Chairman, Senator Landon. We, of course, in the water and the wastewater, we advocate to our members to be very transparent, get ahead of a situation. Of course, there's continual new regulations, new mandates that are coming down. They're going to affect water and wastewater of all sizes and flavors, whether they're municipalities or special districts or water and sewer districts. There's a ton coming down the pike that's going to increase costs. So we really don't see issues because I think everybody does understand that you know what a cost of service was in 1970 is just a little different in 2023. And so they understand the rising costs, and all attempts are made to limit those costs, and being able to spread them over a number of people is beneficial in that respect. But we really don't. And a secondary point that you brought up, Senator Landon, was that, you know, once the petition is approved by the commissioners and then it goes to a vote of the people, and then they have to register the district with the Secretary of State. And at that point in time, they had to have their incorporation documents. They had to have their bylaws, and the bylaws are usually pretty lenient in terms of generalities. And then in the case of water and wastewater systems, because of the regulations and the Safe Drinking Water Act, Clean Water Act, and so forth, a lot of those then create rules and regulations, as well as their other operating documents. And anyone who would come into the district that would want to sign up and get water or wastewater services would be given a copy of those rules and regulations that lay out everything. And again, most special districts have an annual meeting where a lot of these issues are aired, and we participate in probably 150 annual meetings that are held by special districts throughout the state. You know, keep in mind, as I said, improvement and service districts, there's about 80 plus that own and operate water and wastewater facilities out of the 328 community water systems in the state. 96 of those are municipalities, and the remainder are water and sewer or joint powers in some form or fashion. And all of them have similar issues in terms of the bylaws, in terms of rules and regulations. So I think that's the transparency issue. And again, I kind of zeroed back on that legal issue in terms of creating a possible sustainability issue more than anything. And it's while they were probably trying to gun at a particular type of a district, I think it's been brought up that there's 27 different types of special districts that this would affect. And all of them have differing service areas as well as service offerings. And for that, I again say, on behalf of our membership, we're opposed to this bill.
All
I
right,
hope that answers your question.
very thoroughly. Senator Scott.
Mr. Chairman, my question relates to the language that the House added at the bottom of page 3. The prohibition does not apply in a district that has been organized without a petition or charter prior to July 1, 2023. I understand the date, but how many of them were organized without a petition or charter? Does this exempt most of them or just a few?
So Senator Scott, would this be a question for Mr. Pepper or maybe for the bill sponsors?
I think
Mr.
probably
Pe-
both, Mr. Chairman.
Let's start with Mr. Pepper.
Pepper may well know.
Mr. Pepper.
Thank you, Mr. Chairman. Senator Scott, at least in the water and the wastewater world, I'm not aware, a special district can't be created without the commissioners signing off from a petition. So I would be, I don't know of any. Although I say that, and then we are working with a community water system in the Riverton area that we have not been able to find any corporate filing documents, but it was not a special district or anything. It was just a subdivision water association, if you will, like an HOA. But I'm not, just because of the way the statutes were written, I'm not aware of any that were created without the benefit of a petition.
Okay, anybody else? How about you, Representative Stith? Can you help Senator Scott with that question?
Chairman Case, I would agree with Mr. Pepper. 18-12-105 requires a petition in order to form a service and improvement district, so I regard the language at the bottom of page 3 as superfluous. I don't think it does. I don't think it does anything. I think that was sort of an unfortunate House amendment from my point of view.
Gotcha.
Mr.
Senator Barlow.
Thank you, Mr. Chairman. So I appreciate that, but that was put into place in 1977. So are there no service improvement districts that predate 1977? Thank you, Mr. Chairman.
Representative Stith.
Mr. Chairman, Senator Barlow, service and improvement districts were statutorily created in 1977, and prior to that date, you could have an irrigation district, you could have a special district, and there were lots of special districts, but there were not, this classification of service and improvement district did not exist until 1977.
Thank you. Anything else from Mr. Pepper? Anything else from Mr. Pepper?
Yes, Mr. Chairman. Oh, I'm sorry.
I was trying to find out if anybody had a question for you,
Yeah.
but I guess I'll give you a last word. We need to wrap this up.
Okay. Thank you, Mr. Chairman. I would like to expand ever so slightly on Ms. Nemitz's accurate depiction of the particular tool that's available to special districts to have improvement districts within districts. We have one in Senator Scott's area where the Wardwell Water and Sewer District created a improvement district at the behest of county residents who were wanting their roads maintained. And so they voted and it was overwhelming. So this is a tool that is used. It's very effective. And again, I would say just because of the language, the way this bill has been fashioned, we are opposed to it. Thank you, Mr. Chairman.
Thank you very much. Anything else? Thank you, Mr. Pepper. Committee? I think there's nobody else, right, Kelly? Okay, we got nobody in the room, so we're closing public testimony. I've got a couple of questions for the sponsors again that were raised by some of the testifiers. So if you guys would come up. What about the point that was raised from Ms. Nemec about we should be talking about the county resolution and not the petition because the petition is kind of blue sky? So help me with that.
Chairman Case, Ms. Nimitz is correct that the Wyoming Supreme Court held in 2021 in the Winnie versus Hoback Ranches case that the county commissioner's resolution controls whether there's a limitation on taxing power. So that is a true statement of existing law right now. This bill would change that, and the point of the bill is to say that the landowners are the ones who are signing the petition. They're the ones who are deciding to join the district. Improvement and service districts are about people getting together and agreeing to voluntarily tax themselves. And so the policy choice is when a group of landowners gets together to voluntarily tax themselves, should they have control over whether their taxation is limited, or should the county commissioners have that power? And to me, it seems like the policy choice should weigh in favor of the taxpayers as against the county commissioners.
So committee jump in if you wish to, but so what percentage signed the petition? Again, help me out with that.
Mr. Chairman, because
What
I'm sorry, I didn't hear
percentage of landowners signed the petition?
Mr. Chairman, I believe it has to be at least 60% of the
So that's
landowners
more than
within-
half. Yeah,
within a district. I believe that's the requirement.
okay.
Mr. Chairman.
Senator Barlow.
Mr. Chairman, I think the nuance that is elector or landowner by
Right,
definition. Anyway, there's a little bit of a nuance in that, I believe. So
but it
anyway.
does rise to the bar of 60%.
Yes, sir. It does.
Yeah, so it's not like 10% can form a petition and then the county commissioners turn around and really what's relevant is their resolution. So, right?
Chairman Case, if I may, that's the part of it that seems about the Supreme Court's decision that's unfortunate, because you have more than 60% or 60% of the landowners saying, we want to form a district, but we want to have a lid on our taxes. They say that in their petition, and the Supreme Court has said, well, that doesn't mean anything. The only thing that matters is what the county commissioners do.
Okay. I think I get that part. Anybody else want to jump in? Go ahead. But I have another question, and it is about the cause of action for one disinfected individual. Is that a change from current law, or is that just codifying something? So help me with that. Can't anybody sue if they have standing?
Chairman Case, I believe this was discussed 2 years ago at your joint corporations meeting. I don't regard that provision actually as changing the law. Right now, municipalities, for example, they can tax up to 8 mills. If the city council is running short on money, they don't get to say, we're going to tax 10 mills next year. Cities can't do that. County commissioners, same way. They have 12 mill taxing authority. County commissioners can't just tax 14 mills if they feel like it. We're a municipality or a county commission to attempt to do that, then theoretically, any property owner paying taxes would have standing to challenge that. So I don't see this prospect of litigation as being really all that difficult. I mean, all they have to do is do what cities and counties already do, which is stay within their mill limit levies, mill limit caps, if one is imposed.
And under current law, Representative, any person that would have standing, single person, could sue, right? So this, I don't see that this is changing anything by giving a cause of action to a single person.
Chairman Case, that's my understanding also.
Yeah. I mean, I don't know of any instance where you can't sue as an individual, but you have to collect 3 out of 4 can sue or whatever that is. I mean, that seems kind of unconstitutional to me. But, okay, then I think that's all I have. Senator Barlow.
Thank you, Mr. Chairman. So I want to follow up on the example used of the 8 mills for a municipality. 8 mills for a municipality, and I would assume most charge the entire 8 mills. But if they provide water or sewer or some other service, they're also charging a fee for that. So if we were to apply this to municipalities, they would no longer be able to do that if they were charging the entire 8 mills. Would that be accurate based on the assertions being made in this bill? Thank you.
Representative Stith.
Mr. Chairman, Senator Barlow, it's statutory law that a city cannot assess more than 8 mills of property tax. They can and have the power to have enterprise funds to charge water and sewer fees, of course. They can do that. So this bill would say that if landowners got together and they set a cap, if it turned out that cap was not sufficient to provide the services that they want to provide, then it would require a vote of the landowners to change it.
So Representative Stith, about Mr. Pepper's contention about districts that have kind of sub-districts within them, is that affected by this, and how is it affected by this?
Chairman Kiss, I don't know. I think this bill would mean that a service and improvement district would be, with respect to any given taxpayer, would be bound by whatever limitation would be set forth in the petition. That would not, except for bonding, of course. Bonding is excluded in the bill.
So the petition could envision sort of a dual system, a two-part tariff, if you will, maybe a mill levy and then a special assessment on top of it for people that have a subservice from the district. Could it envision that?
Mr. Chairman, I think that the structure of the bill would allow the landowners in the petition to structure any kind of limitation how they see fit in the petition. That is, in the petition, you could have a dual structure in your petition if you so chose.
Okay, thank you. Who's next? Senator Landon.
So thank you, Mr. Chairman. Just to follow on to that line of conversation, Representative, I guess I could envision legal counsel drawing papers up that would give flexibility on the fee front, for example, just maybe not on the mill levy front. Can you speak to that a little bit? It seems like in the original charter or the original petition and bylaws, you would just want to structure that according, or does this bill take all flexibility away?
Representative Stith or Representative North.
Mr. Chairman, Senator Landon, I believe that what the bill would do is put the power in the hands of the landowners in their petition to structure whatever limitations they might want. And so you could have, I don't think this bill forecloses or prevents having a dual fee structure, as long as that's set forth in your petition. The idea is that people know what they're voting for.
Okay, Representative Northrop.
Thank you, Mr. Chairman. Also, the people who are within that service district could easily go to the county commissioners and say, we need to revise our petition and get a different set in it, so that, or different wording in it, so that they could do a whatever you want to call it, a subset. So that they can do whatever, like build new roads or maintain roads or whatever the case may be, with the understanding that as long as the group of people that have voted on it and have said that that's what they would like to do from that particular district was in compliance with it.
Makes sense. Anybody else? I can see when Landon's face gets all scrunched up a little bit.
That's age, Mr. Chairman.
Okay, anything else? Thank you, gentlemen. Committee, you've heard the testimony. What's your pleasure?
I'll move the bill.
Got a motion by Landon, discussion? Barlow.
Mr. Chairman, just by the very nature of this bill, does this fall under the ex post facto, where we are making a law that goes back and changes what people would have understood the law would have been at the time when they formed their district, et cetera? I'm just curious. I got 80 years of legislative experience here, and I just don't know. I'm asking, wondering. Thank you, Mr. Chairman.
Senator Scott?
Mr. Chairman, I will say I'm pretty well torn on this bill, and you're getting at some of exactly what. You get limitations placed on the formation that enable you to sign it to start with, and you think you got it limited. And then these have been around, some of them, for 40 years and whatnot, and the world changes on you. We don't really have a good mechanism to revisit that. This starts to provide one, but it seems to be working currently for most districts. and we've got one that's fighting. And I have trouble, I think we need something. The bill's going in the right direction. But I'm not sure it gets the job done properly. Mr. Chairman, I think there's a need here, all right.
Okay, Senator Landon?
Mr. Chairman, I was chairman of the Corporations Committee with all of you, save for maybe a couple at that time. Senator Boner was off chairing other things. And we passed this similar bill back then with the notion that that it made sense that you had to abide by what you set down in your charter, your bylaws, the initiation of your special district, just to protect the taxpayer. But I'm with Senator Scott, I totally get the fact that there's a flip side of the coin, which is the concerns that have been raised this morning. So I think there's policy stuff here. I just, it's not very clear cut. It's not very easy to throw a blanket over the whole thing.
So, and Senator Barlow, to your direct question, I think indeed if there is a district that is charging or assessing in excess of their petition right now, I think that this bill could be used to rein them in, or at least force them to get their members to agree to what they're doing. I don't think that's the end of the world, but I in that sense, it is sort of retroactive. Back to you, sir.
Thank you, Mr. Chairman. And so one of the unique features of this type of district is this differential of assessment. Someone gets more benefit can be charged more. And that gets to the one person getting charged the end of the road. You're going to be getting more mileage of maintenance or whatever, you get charged higher. If that one increase of assessment by this bill is the only one that gets tipped over that maximum from the petition, then that would be a cause of action under this. And that is a unique feature, I would argue, within this particular type of service district, is this differential based on, it says frontage. I mean, there's several verbs that they use in there, or nouns they use, that you can be charged more because you get more service. And it's part and parcel to the powers of the district. So I think that creates another uniqueness within this that is not just straightforward. Everybody does not have the same maximum, i.e. the same mill levy or the same assessment. There is a potential for differential within the current act as it stands. Thank you, Mr. Chairman.
I totally agree, Senator Barlow, but I think you could also put that in your petition, that there is, the mill levies are capped at X, but we will have special fees for Y. Maybe those are unforeseeable at the time, but then that's another reason to go back to your members. The part that I'm coming back to is it's not a bad thing to go back to the people on this stuff. That gives me some comfort. But anything else? Are there any, we've got a motion on the bill. Are there any proposed amendments? Does anybody want to take out what the House did just to be naughty? Because it really doesn't make sense, but.
Mr. Chairman, it's harmless.
It's harmless. Yeah, I agree with you, it's harmless. Any discussion, any more amendments? Anything? Debbie, would you call the roll on this bill, please?
Senator Barlow? No. Senator Boner?
No.
Senator Landon?
Aye.
Senator Scott?
Aye.
Mr. Chairman?
Aye. Okay, 3 ayes. Probably won't have Barlow and Boner carried on the floor. Got another Cotton Pappas. You got some ringers in there. You better talk to him.
Mr. Chairman, yeah, that name right there, I guess I'll take it upstairs.
Okay.
I was kind of hoping you'd all be behind me if I go down upstairs.
Thank you very much. We're adjourned. So get your interim topics in by Friday? Is that right, Debbie, Kelly? And then we'll meet next week, I think Wednesday, right? With our friends down the hall. Okay.